Welcome back to this third part of law sessions relating to land law, and in particular, we're covering registered land in this section. And in the last segment, we looked at unregistered land and the rules which apply for unregistered land. Now, the system of unregistered land, and in respect of unregistered land, unregistered title, developed over centuries by the common law and equity. But this was reformed by the 1925 Law of Property Act. But that is not to say that unregistered land is well and truly dead. It must be that the rules that are still relevant, as I say, will certainly be relevant as it relates to that small amount of unregistered land which still remains. However, it is being largely replaced by the system of registered title. Now, if you remember in the last segment, I briefly touched on registered land and the type of conveyance in there. Now, the complete takeover by the registered title system is guaranteed by the compulsory registration system. This means that when a trigger event, which is a particular dealing that you do with unregistered land, takes place, then the title must be registered. And so there are certain trigger events, for example, when you lease the property, when you sell the property, when you give a bank a mortgage on the property, then of course these act as trigger events to take unregistered land into the registered land conveyancing system. It is compulsory in that if registration does not take place, then the legal title will revert back to the person who granted it or who conveyed it. Now, the primary aims and principles which underpin registration is first to remove the necessity of title deeds, meaning that you had to show root of title going back for 15 years. So with registration, the idea is to look in one place for all the information relating to a piece of property. So the first aim, as it were, was to remove the necessity of title deeds. And secondly, of course, was to make conveyancing easier. Now, if we go back briefly, and in the run-up to the passing of the Law Commission, who of course would certainly consider these matters, we see that there was a Law Commission report in 1996, and the Law Commission and the District Land Registry began a joint program in order to update the law and consider reforms in relation to the statutes which govern land registration. Now, if you think about this, it had been a while, given that it would have been 1925 when the main pieces of legislation had come in. Now, in that collaboration between the Land Registry and the Law Commission, the initial proposals were published in a report, Land Registration for the 21st Century, a consultative document. And of course, you can always look for this Law Commission report and have a read of it. It was September 1998. And what we see is that the revised recommendations, which were amended in light of the consultation response, were then published in another paper, the Land Registration for the 21st Century, a Conveyancing Revolution. And that was in 2001. Well, the Act, the 2002 LRA, Land Registration Act, implemented most of the recommendations, and the joint report contains a detailed discussion of the policy which gave rise to the recommendations. Equally, there are full explanatory notes in each of the clauses of the draft bill in relation to the report. It was said of the law before the new act that the principal legislation was provided by the LRA 1925, as well as amending legislation such as the Land Registration Acts from 1936 through to 1997, and of course the Registration and Land Charges Act 1971. Now, the legislation provides a system which is far more improved and allows conveyancing to be a lot simpler. And so, when we look at registered conveyancing, with this updating of the legislation, it seems to operate a lot better. However, what we will see is that there are still some slight concerns when it comes to certain aspects of registered land. Now, let's consider exam questions for a minute. The vast majority of exam questions nowadays tend to be on registered land, meaning ON, registered land. So the vast majority of exam questions refer to registered land as opposed to unregistered land. So most of the questions, and the average exam paper will have 8 questions on it, there is a very good chance that at least 6 of them will be about registered land. So if an exam question says X is the registered proprietor of Blackacre, you're dealing with a registered land question. So in registered land, we have to consider the framework. There are 3 registers. There is the property register, which describes the type of land, and it gives a number which is then assigned to the property. Also included on the property register, of course, is a plan. We then have the charges register, and this will show all the encumbrances on the land. Now, if you remember what I said in the segment to do with unregistered land, this is about the only time that we see any kind of overlap in relation to the 2 systems of conveyancing, because here also we have got a charges register. Certainly as it relates to unregistered land, you're looking at the charges register also. And the third register, of course, is the proprietorship register, and that gives the name and address of the estate and owner, the nature of the estate, and any type of restrictions on the property in relation to ownership. Now again, I will emphasize that in order to properly understand registered land, you must know how particular interests are dealt with in relation to registered land. So you need to know if the examiner says there is a sale of land, but then there is someone on the land with a legal lease. What is the effect of that? The 3 important sections of the LRA that you will need to grasp will be the areas dealing with substantive registration under section 27. You will need to know about the area dealing with interests which override a registered disposition, which is Schedule 3. And you also need to know about Section 34 and Section 43 of the LRA, which deal with notice or restriction. Now, the point here is that we have considered in a previous segment unregistered land. Looking at registered land here, if we were to consider the effect of a legal lease, for example, in unregistered land, the idea of a legal lease and it being a legal right, and I gave you the example of what if I have a 2-year lease. In unregistered land, legal rights bind the world, whether they know about them or not. And that's the end of the matter. So again, if you remember, I said to you, if I move to America and somebody else who wanted to buy the land, a purchaser comes along, but he doesn't see me on the property, it is irrelevant if I have a legal lease in unregistered land. What is the effect of that in registered land though? Well, this is where Schedule 3 to the LRA kicks in. Let me emphasize that in the context of registered land, the area you need to grasp is Schedule 3 to the LRA, because exam questions have a huge focus on Schedule 3. So, looking at those 3 then, Section 27, Schedule 3, and Section 34 or 43, let's consider each in turn. Section 27 of the LRA 2002 talks about dealings which must be completed by substantive registration. So, it says that there are certain types of dealings with land which you must substantively register. So the first that it flags up is that any transfer or any sale of land must be substantively registered. It goes through a process in order to register it. The next type, of course, is a legal lease, which is granted for more than 7 years over the land. That is an unusual one, but it did come about in the update and in the consideration of changing the law, because the government, by and large, was concerned that it wasn't getting the type of revenue from commercial land as it should. And so by reducing it to 7 years, it meant that it will catch, or was intended to catch, a vast majority of commercial type properties. So, transfer or sale of land, legal lease for more than 7 years, a legal lease which is granted over the land, but the legal lease does not take effect in possession until 3 months after the date of the grant. Now, you must substantively register that. What do I mean? Let's say you have a two-year lease, for argument's sake, and you're off to university. So you're going to university. No, let's give you a 1-year lease. You're at university. You're not sure if you're going to stay this course after year 1. So you're at university for 1 year, but let's say you go in May and you get your accommodation and you decide that you are going to then go into occupation in September. So from May to September, you're looking at about 4 months. Now, the point is that even though it is a legal lease, because you're not taking possession immediately until after 3 months from the date it is granted, the law says that you need to substantively register it. And that makes sense, because if a purchaser coming to look at the property, you would certainly not have anything in there until you get there in September. And that, of course, would not do in the context of registration, because the idea of the register is to let people know what kind of dealings are being considered in relation to the land. The other thing that needs to be registered substantively is an express grant or a reservation of a legal easement over the land, and a grant of a legal charge over the land. So if you have an express grant of a legal easement or an express reservation of a legal easement, it is a Section 27 substantively registered interest. We will, of course, look at that in more detail when we look at easement, but for our purposes, those are the two that need to be registered substantively under Section 27. Now, for all of the points that I've raised in relation to registration, if you do not substantively register, then a purchaser of that land who pays valuable consideration will, of course, not be subject to your interests. And that simply means, for example, let's assume you've purchased the land, but you have not substantively registered it. Let's assume you have a 7-year lease, which has not been substantively registered. The point is that if that seller then sells it to someone else, and your interest hasn't been substantively registered, then as long as that purchaser pays valuable consideration, he's not concerned with your interest. And that is what registration does. Now, Schedule 3 is extremely important. As I say, these are the ones that you must look out for. Schedule 3 to the LRA 2002 considers interests which override a registered disposition. It is so important that I will make it the starting discussion immediately after the break.